Ivanka Trump has now been linked to newly uncovered evidence in a federal investigation that her father has been working urgently to derail. And the judge presiding over the matter has issued a signal that sent his legal team into overdrive. Federal investigators, reviewing financial records subpoenaed from Deutsche Bank, identified a sequence of wire transfers funneled through a shell entity that was never meant to attract outside scrutiny beyond the Trump Organization. The entity, DJT Consulting LLC, was incorporated in Delaware in 2018 and quietly dissolved 3 years later. Roughly $14.7 million flowed through this structure, passing across 3 intermediary accounts before ending up in a trust tied to Jared Kushner's family office. The pivotal detail is that 2 of those transfer authorizations bear Ivanka Trump's signature. Since 2021, Ivanka has pursued a strategy built on distance, maintaining silence through indictments and courtroom drama. Prosecutors now possess documents carrying her name from her tenure in the White House that tie her directly to transactions central to a federal fraud inquiry. For years, Deutsche Bank stood as the lone major lender willing to extend credit to Donald Trump after institutions such as J.P. Morgan and Goldman Sachs withdrew amid concerns over repeated defaults and disputed asset valuations. When investigators compelled Deutsche Bank to produce its records, they uncovered extensive documentation, including files related to DJT Consulting LLC. Those records placed the shell company squarely within the broader financial web now under examination. DJT Consulting LLC did not operate as a functioning advisory business, lacking employees, office space, a website, or revenue from legitimate consulting activity. Instead, it functioned as a conduit designed to shift funds among Trump Organization entities and related family trusts in ways that blurred the source and destination of the money. Through that mechanism, $14.7 million appeared to vanish from one ledger and resurface on another without a transparent trail. The transfers took place between March 2019 and August 2020, when Ivanka was serving as a senior advisor to the President of the United States. Forensic accountants reviewing the flow of funds described the pattern as consistent with structures intended to bypass standard reporting obligations. For years, Ivanka's attorneys have advanced a narrative that she was detached from core financial decision-making and lacked meaningful involvement. That argument is now under strain because her signature appears on 2 wire authorization forms. Investigators also located internal memoranda stored on the company's cloud server outlining a broader effort to restructure Trump Organization assets. Ivanka's name appears among the recipients of communications describing plans to shift money through entities that prosecutors contend were structured to mislead creditors, financial institutions, and tax authorities. Her counsel may assert she never closely reviewed those communications, but her name is now embedded in the evidentiary record. In response, Trump's legal team mounted a coordinated counteroffensive anchored in 3 principal claims. They argued that executive privilege shields documents signed during her White House service from disclosure. They contended that attorney-client privilege protects transactions carried out under legal guidance. They also suggested she signed materials presented by executives without detailed awareness of their substance. Each of those positions faces significant obstacles under existing legal standards. Executive privilege does not extend to private commercial dealings, and courts have already applied the crime-fraud exception in this case to limit attorney-client protections. The assertion that she lacked knowledge of what she signed raises its own risks, implying either informed participation or striking carelessness involving $14.7 million. On Truth Social, Donald Trump responded forcefully, labeling the investigation a political attack and criticizing the judge and prosecutors in blunt terms. At a rally in South Carolina, He referred to her as my Ivanka, projecting a level of personal protectiveness he has not consistently shown toward Eric or Don Jr. That tone underscores how seriously he appears to view the evidence now emerging. Judge Margaret Torres signaled her direction during a recent status conference by posing pointed questions and ruling swiftly from the bench. She asked prosecutors whether they intended to classify Ivanka as a witness or as a subject of the investigation. Within 15 minutes, she rejected Trump's executive privilege motion, stating there was no colorable basis for the claim. She then set an evidentiary hearing and ordered Ivanka Trump's legal counsel to appear. Court observers noted that the judge appears focused on moving the case forward rather than entertaining delay. Efforts to resist disclosure may have accelerated the timeline rather than slowed it. Critics point to a recurring pattern in which proximity to Donald Trump has carried legal consequences for close associates, including Michael Cohen, Allen Weisselberg, and Rudy Giuliani. Even Eric Trump faced intense scrutiny when his father referenced him under oath in connection with disputed financial statements. Those episodes form part of the backdrop against which this new development is unfolding. The legal exposure now appears to be edging closer to the family's inner circle. Some commentators have contrasted the Trump model of a family-centered enterprise with the institutional approach taken by Warren Buffett at Berkshire Hathaway. Buffett deliberately separated family from management, selecting Greg Abel as his successor based on professional criteria rather than lineage. He has long argued that blending family ties with corporate governance invites instability. As the Trump brand faces sustained challenges in courtrooms tied to signatures on shell company paperwork, Berkshire Hathaway reports holding $381.6 billion in cash. The comparison highlights divergent philosophies about legacy, control, and risk. An evidentiary hearing is set for next week, and the proceedings are expected to clarify whether Ivanka's role will expand within the investigation. Although she relocated to Miami and largely withdrew from public political battles, the documentary record from the critical period continues to follow her. Paper trails rarely fade on their own, especially when financial institutions and federal investigators are involved. The coming hearing may determine whether her strategy of distance can hold under legal scrutiny. For now, the signatures at the center of the case remain fixed in ink. Behind the scenes, prosecutors are said to be refining a timeline that maps the flow of funds against internal communications and public statements made during that same period. The objective is not theatrical, but methodical, to determine who knew what and when decisions were made. Financial investigations often turn less on rhetoric and more on sequence, and the sequencing here appears increasingly precise. Each wire transfer carries a timestamp, each memo a distribution list, each authorization a signature anchored to a specific date. In complex cases involving layered entities, clarity often emerges not from a single document, but from the convergence of many small details. Legal analysts note that evidentiary hearings can become pivotal moments because they test arguments in real time before the court. Unlike broad motions filed on paper, these proceedings require counsel to answer direct questions under scrutiny. If the court finds sufficient basis to probe further, the scope of inquiry can widen quickly. That prospect alone can reshape negotiation dynamics behind closed doors. Even the classification of a person as a witness rather than a subject can carry strategic implications that ripple through the defense's approach. The trust connected to Jared Kushner's family office has also drawn attention, not as an accusation in itself, but as part of the financial architecture under review. Trust structures are common in high-net-worth planning, yet investigators appear focused on how and why funds were routed through multiple layers before arriving there. The use of intermediary accounts is not inherently unlawful, but when paired with opaque corporate vehicles, it invites closer examination. Prosecutors are reportedly assessing whether the layering served a legitimate commercial purpose or primarily obscured visibility. That distinction may become central as the hearing unfolds. For Ivanka, the political dimension complicates the legal one, even as her public posture has been restrained. She has avoided commentary on the investigation, offering no extended defense in interviews or statements. That silence may reflect legal advice rather than indifference, yet it leaves a vacuum filled by court filings and speculation. In high-profile matters, absence can sometimes amplify scrutiny rather than reduce it. The more the documentary record circulates, the more her previous efforts to distance herself from operational decisions face renewed examination. Donald Trump's broader campaign schedule continues alongside the legal calendar, creating parallel narratives that intersect but do not fully merge. Public rallies project confidence and grievance in equal measure, while court proceedings move at their own measured pace. The contrast between those arenas underscores the separation between political messaging and judicial process. Judges are guided by evidentiary standards rather than applause lines. As next week approaches, attention shifts from rhetoric to records, from speeches to signatures, and from broad claims to specific transactions anchored in time. Court filings in the days leading up to the hearing are expected to sharpen the focus on intent, a concept that often determines how financial conduct is ultimately characterized. Prosecutors will likely emphasize patterns that suggest coordination rather than coincidence, pointing to repeated structures and mirrored transactions across related entities. Defense counsel, in turn, may argue that large organizations routinely rely on delegated authority and standardized paperwork. The question is not simply whether her signature appears, but what that signature signifies within the broader operational chain. In cases involving layered corporate governance, lines of responsibility can appear both clear on paper and diffuse in practice. Financial experts observing the case have noted that the use of Delaware entities is commonplace in American business due to favorable corporate statutes. The mere existence of a limited liability company registered there does not imply wrongdoing. What draws scrutiny is the absence of ordinary business markers such as employees, revenue streams, or client contracts. When an entity appears to function solely as a conduit, investigators naturally probe its purpose with greater intensity. That inquiry becomes more pointed when the entity dissolves shortly after substantial funds have passed through it. The role of Deutsche Bank remains central because financial institutions are required to maintain detailed compliance records under federal regulations. Suspicious activity reporting frameworks obligate banks to flag unusual transactions, though those reports are confidential. Whether any internal flags were raised at the time remains unclear from public filings. What is clear is that once records were subpoenaed, they provided a roadmap of transfers that might otherwise have remained obscured. In financial investigations, banks often serve as reluctant archivists of decisions made far beyond their boardrooms. Inside the courtroom, Judge Torres is likely to press both sides on narrow questions rather than sweeping narratives. Judges in complex financial matters often seek to isolate discrete issues before addressing broader themes. If prosecutors argue that the crime-fraud exception applies, they must demonstrate a credible basis that communications were used in furtherance of misconduct. If the defense asserts privilege, they must articulate boundaries that withstand doctrinal scrutiny. These exchanges, though technical, can carry consequences that extend well beyond the immediate ruling. For Ivanka, the calculus may hinge on whether her role is framed as operational, advisory, or ceremonial. Titles within family-run enterprises sometimes blur those categories, especially when business and public service overlap. The period in question coincided with her time in government, adding another layer of sensitivity. Federal ethics guidelines impose certain expectations, even if they do not automatically govern private family transactions. That intersection of public office and private finance remains a backdrop that prosecutors appear prepared to explore with care. Meanwhile, political allies have largely avoided detailed commentary on the substance of the allegations, instead reiterating broader themes about fairness and due process. That restraint may reflect recognition that evidentiary hearings are less amenable to partisan framing. Markets, for their part, tend to respond not to rhetoric but to tangible risk, and investors watch high-profile legal disputes for signals about stability. The Trump Organization has weathered legal scrutiny before, yet each new proceeding introduces fresh variables. As documents accumulate and arguments narrow, the case moves incrementally from speculation toward adjudication. As the evidentiary phase approaches, attention is also turning to the mechanics of how testimony might unfold if it becomes necessary. Federal proceedings often begin with documentary foundations before any witness takes the stand, allowing the paper record to frame the narrative. Should Ivanka be called to clarify her role, questioning would likely focus on process rather than personality. Lawyers on both sides understand that tone can matter as much as substance in high-visibility hearings. A measured exchange can reinforce credibility, while defensiveness can invite further inquiry. The structure of DJT Consulting LLC continues to anchor much of the scrutiny because shell entities, while legal in many contexts, raise concerns when their activity appears narrowly transactional. Corporate law permits broad flexibility in how companies are formed and dissolved. Yet regulatory frameworks assume transparency when funds cross institutional boundaries. Investigators are said to be comparing internal accounting entries with external bank confirmations to identify any inconsistencies. Small discrepancies in description or timing can become significant when repeated across multiple transactions. There is also the matter of governance within the Trump Organization during the period in question. Family-led enterprises often rely on overlapping roles, with titles reflecting influence rather than rigid departmental lines. That dynamic can complicate later efforts to assign responsibility with precision. If prosecutors argue that certain executives coordinated financial restructuring, they will need to show how directives flowed through the organization. Defense attorneys may counter that strategic decisions were compartmentalized and that signatures reflected routine administrative approvals. Observers note that high-profile financial cases frequently hinge on how jurists interpret intent embedded in routine paperwork. Authorization forms can appear formulaic, yet courts often examine surrounding circumstances to determine whether they were mere formalities or deliberate acts. Context becomes critical when documents intersect with ongoing negotiations, debt obligations, or regulatory reporting deadlines. The fact that the transfers moved through multiple intermediary accounts may be characterized in different ways depending on that context. Establishing a coherent narrative from technical records is often the central task of such proceedings. Public reaction remains divided but relatively muted compared with earlier legal controversies. The absence of dramatic courtroom scenes has kept much of the focus within legal circles rather than cable news panels. That quieter atmosphere does not diminish the stakes, which revolve around compliance, fiduciary duty, and potential exposure. For Ivanka, the challenge lies in reconciling her previous portrayal as removed from operational finance with documentary evidence that places her name on key approvals. As the hearing nears, the emphasis continues to shift from broad assertions toward the granular details embedded in signatures, timestamps, and internal correspondence. Beyond the immediate courtroom strategy, federal investigators are said to be evaluating how the transfers align with contemporaneous financial pressures facing the organization. Debt maturities, refinancing negotiations, and asset valuations often create moments when liquidity becomes especially sensitive. If the timing of the $14.7 million movement coincided with such inflection points, prosecutors may argue that context matters as much as structure. Defense counsel is likely to respond that businesses routinely reposition capital to manage cash flow and investor expectations. The difference between prudent management and problematic concealment can hinge on documentation that appears mundane at first glance. Compliance specialists note that modern banking systems generate extensive digital trails, from internal approvals to automated monitoring alerts. Each wire transfer typically produces metadata reflecting origin, destination, routing numbers, and review protocols. When multiple intermediary accounts are involved, those trails lengthen rather than disappear. Investigators often reconstruct these pathways visually, mapping transactions across time to identify patterns that might not be obvious in isolation. Such reconstructions can transform abstract numbers into chronological narratives that courts find easier to evaluate. The involvement of a family trust introduces another layer of legal nuance. Trusts are frequently used for estate planning and asset protection, particularly within affluent families. Yet, when funds arrive through a dissolved entity that lacked operational substance, questions arise about purpose and transparency. Prosecutors may seek to determine whether trustees were aware of the full transactional history behind the deposits. Defense attorneys could argue that trusts operate independently and that beneficiaries are not necessarily privy to every upstream movement of capital. Within the broader political landscape, the case unfolds against a backdrop of ongoing campaign rhetoric and policy debates. That parallel track underscores the distinction between electoral messaging and judicial fact-finding. While public statements may frame the investigation in sweeping terms, courtrooms operate through narrower lenses. Judges weigh admissibility, relevance, and procedural fairness rather than public opinion. The separation between those arenas can create a dissonance that becomes more pronounced as legal milestones approach. As filings accumulate, the record grows more detailed and less abstract. Each submission adds citations, attachments, and clarifications that refine the contours of the dispute. For Ivanka, the central issue remains how her documented actions will be interpreted in light of her asserted distance from financial operations. Signatures, once routine administrative acts, now carry amplified significance because of the surrounding scrutiny. With the hearing imminent, the case continues to evolve not through dramatic revelation, but through incremental clarification anchored in the documentary trail. What may ultimately shape the court's assessment is how consistently the documentary record aligns with the explanations offered in response. In financial litigation, discrepancies do not need to be dramatic to attract scrutiny. Even subtle inconsistencies can invite further questioning. Prosecutors are likely to test whether the stated purpose of DJT Consulting LLC matches the movement of funds reflected in bank confirmations and internal ledgers. If the entity was described in one context as advisory but functioned solely as a conduit, that distinction could become consequential. Defense counsel, meanwhile, may emphasize that corporate entities often evolve in purpose over time, particularly within privately held organizations. Another dimension involves the internal culture of decision-making during the period in question. Large family enterprises sometimes rely on informal communication channels alongside formal documentation. Emails, calendar entries, and draft memoranda can reveal how strategic discussions unfolded before paperwork was finalized. Investigators typically compare these informal exchanges with executed documents to determine whether signatures reflected active engagement or procedural endorsement. The absence of direct commentary from Ivanka in those exchanges could be interpreted in multiple ways, depending on context. The timing of the entity's dissolution in 2021 also remains under quiet examination. Dissolving a limited liability company is not unusual, especially after it has served a defined purpose. Yet, when dissolution follows significant transfers, regulators often ask whether all reporting and tax obligations were fully satisfied. Prosecutors may review whether final filings accurately captured the company's activity. Defense attorneys are likely to argue that closure simply marked the end of a restructuring phase rather than an attempt to obscure history. For the judge, the evidentiary hearing offers an opportunity to clarify boundaries before any broader determinations are made. Courts often prefer to resolve privilege questions and scope issues early, reducing ambiguity as a case advances. If certain documents are deemed admissible, the strategic landscape shifts immediately. Conversely, if protections are upheld, prosecutors may need to recalibrate their approach. These procedural decisions can carry weight equal to that of substantive findings. In the background, financial markets and business partners observe developments with measured attention. Even absent formal charges, extended litigation can affect negotiations, lending relationships, and reputational assessments. For Ivanka, the calculus involves both legal exposure and long-term positioning beyond politics. The narrative that once centered on distance now intersects with tangible documentation that invites closer examination. As the record continues to expand, the case advances not through spectacle, but through the steady accumulation of facts placed before the court. As attorneys refine their arguments, much of the focus centers on how responsibility is allocated within complex organizations. Corporate hierarchies often distribute authority across layers, allowing senior figures to rely on subordinate expertise. Prosecutors may attempt to demonstrate that certain transactions were significant enough to warrant personal review rather than routine approval. The defense is likely to counter that large enterprises depend on trust in established internal controls. That tension between oversight and delegation lies at the heart of many financial disputes. Investigators are also expected to examine whether any external auditors reviewed the transactions during the relevant period. Independent accounting firms typically assess internal controls and financial disclosures, though their mandate has limits. If auditors flagged unusual activity or sought clarification, those communications could become relevant. On the other hand, the absence of objections might be cited as evidence that the transactions appeared consistent with ordinary practice at the time. In financial cases, silence from oversight bodies can be interpreted in more than one way. The broader regulatory environment during 2019 and 2020 adds context to the analysis. Economic volatility and shifting credit markets created pressure across numerous industries. Businesses recalibrated asset structures, renegotiated loans, and adjusted reporting strategies to maintain stability. Prosecutors may seek to distinguish between industry-wide adaptation and specific conduct, unique to the organization in question. Defense counsel will likely emphasize that capital restructuring was common in a period marked by uncertainty. Publicly, Ivanka's continued absence from commentary has reinforced the impression of a deliberate legal strategy. Silence in such circumstances can signal discipline rather than retreat. Yet in a media environment that often equates visibility with accountability, that restraint leaves others to define the narrative. Each new filing becomes a surrogate statement, shaping perception through formal language rather than televised interviews. The courtroom, not the campaign trail, remains the arena where facts will be weighed. As the hearing draws nearer, both sides appear intent on narrowing the dispute to core legal questions. The case is not about sweeping political themes, but about specific documents, defined entities, and measurable transfers. Whether those elements coalesce into a finding of liability depends on how convincingly each side frames intent and knowledge. For now, the record continues to expand in measured increments, each addition contributing another piece to a mosaic still taking shape.